Since 1992, the Center for Continuing Education, CCE, has presented seminars featuring the best in topics and talent. Our programs are available in online, DVD, and CD formats. CCE can also customize seminars for your law firm or corporate law department needs. For information and forms on how to earn participatory MCLE credits with this program, visit www.cce-mcle.com. The Center for Continuing Education is a State Bar of California approved MCLE provider.
The Center for Continuing Education, CCE, is a State Bar of California MCLE approved provider. CCE certifies that this program is approved for 1 hour of MCLE credit. CCE, the Center for Continuing Education, presents Patent Fundamentals for Non-Patent Attorneys, presented by Stephen A. Nielsen of Larkspur, California.
Steve Nielsen is a founding partner of Allman & Nielsen, based in Marin County, California. Mr. Nielsen is a U.S. registered patent attorney with many years of experience in obtaining patents and achieving favorable results in federal court in the field of intellectual property litigation. He is the current chairperson of the Intellectual Property section of the Marin County Bar Association. Mr. Nielsen received his J.D. in 1987 from Bolt Hall, University of California at Berkeley, and also holds a B.A. in computer science.
Good afternoon. Thank you all for coming here. I hope to put on a interesting and informative presentation on patent fundamentals for people who are not registered patent attorneys. My goal is to convey 5 concepts to you. What is a patent? What might be patentable in 2010? What are the important deadlines that you might want to be able to convey to your client so you don't blow any statutes of limitation? There's just a couple deadlines you need to know so when a client comes in, you don't do anything to harm their interests. Then I want to talk about what patent work can you perform even though you're not a registered patent attorney. Then conversely, what patent work or patent punishment, as I call it, is reserved for registered patent attorneys. First of all, what is a patent? A patent, if you're lucky enough to get one, looks like this. It's issued by the United States government. Thomas Jefferson was our first patent examiner and patent commissioner. And so it's issued by the United States of America. It comes from an organization called the United States Patent and Trademark Office. And what this is, it's a right to exclude others from manufacturing, importing, or selling items within the United States. It's not a right to make things, it's a right to exclude others. And it excludes things such as a product, a machine, a composition of matter, a plant, a design, a machine, anything that's, quote, covered by the patent. Now, the next important issue to understand is what is covered by the patent. What's covered by the patent are the contents of the claims, and in a patent, the claims are always found at the very end of the document. So you have this right to exclude others. Sometimes many good patents are for compositions of drugs or new treatments, so you may need FDA approval, or sometimes a patent is an improvement upon an existing product, and if the existing product is still in its patent, the inventor may need to get a license to practice his invention. Patents in this country are good for 20 years from the filing date, which is in parity with other countries, as our patent office tries to be in line with other countries so that we have a more unified system throughout the world. So if your client is lucky enough to have a patent, he or she can stop imports from people bringing the covered product into this country, and they can stop the domestic manufacture or sale of products covered by the patent. So there is no international patent if you want a patent in Germany, you have to go to Germany, file, and you get some document. It looks like this. So each country has their own patent office. Each country wants to get their fees, and each country has their own unique quirks about granting patents. So people come in, they want an international patent. There's no such thing as that. Sometimes a client will come in and they'll have a gadget or an invention, and they'll go on Google and they'll look for some patents, and they'll find a picture just like it, and they'll say, oh, am I going to get sued for making this? Well, you need to tell your clients that the patent only excludes what's covered, again, in the claims. The claims are found at the end of the document, so don't be discouraged if a picture of the product is in an existing patent or described in general. Again, it's just the claims that your client needs to worry about if they're worried about infringing on a product. And what's interesting, with Google Patents, clients can do their own searches, and they find a lot of interesting things, and they have a lot of interesting questions to go through about the various products that they may have invented or that they want to invent. So number 2, what might be patentable in 2010? Various clients will come into your office and they'll show you a gadget and they'll ask, is this patentable? And probably your best answer, if you're not a registered patent attorney, is to say, go ask a registered patent attorney. It's hard to say unless you're doing this day in and day out because the law changes. But if they press you, you may want to give them some general guidelines so you don't get their hopes up too high. Generally, in the last 5-10 years, patents are more difficult to obtain than they were in the past. There's sort of a public outcry about excluding others from inventions that might be considered obvious. And some people find patents to have an anti-competitive effect. Other people really believe, as I do, that patents help reward innovation. People spend money on R&D and they get the patent and they profit from it, and then they have more money to reinvest. But we're not going to solve that issue here. But the trend is things are more difficult to patent now than they were in the past. So the first 3 considerations you may want to tell your client about is that a invention, process, material has to be new. So that has 2 different types of meanings. One is your client cannot have offered it for sale or used it in public for more than 1 year before your initial patent filing. And we'll talk about that more in the deadline section. So it has to be new. They can't be using it for 5 years and then file for a patent. Then the item has to work or be useful. It doesn't have to work perfectly, but it has to have utility. And there are plant patents, utility patents, and design patents. And by utility, it has to have some value to it. Now, fortunately, the threshold is very low. There's a famous case involving some semiconductors that didn't work. And during the prosecution of the patent attorney said, well, the utility is it can be used for landfill. You can fill things up with it. And the patent office said, no, that's too low. It has to be better than landfill. But the standard isn't much better than landfill. So it has to have some utility. It doesn't have to work perfectly. Then here's what we're going to spend some time discussing. The methodology of the invention has to be unobvious. In other words, if someone were to come in and say, I have a pencil with an eraser on top, the patent office would say, well, that's an obvious combination of known components. One skilled in the art would have thought about putting an eraser on top of a pencil and calling that a product. So what your client needs to do is think about how their invention is not obvious to one reasonably skilled in the art. And the big case on this is called KSR versus Teleflex. That case involved a sensor on a gas pedal, electronic sensor on a gas pedal. The gas pedal would be pushed down. It would send a control signal to the carburetor or fuel injection, open it up through the sensor. So we know about sensors. We know about pedals. Somebody got a patent for that. It went to court, and the court said, no, that's an obvious combination of known components. We're not going to uphold a patent for a gas pedal on a sensor. So the case law is in a state of flux, and the next couple of years we're going to get a more definitive answer as to what is obvious and what isn't. The guidelines are, if one reasonably skilled in the art would consider trying this particular invention, and a good example is if you have a 5-spoked wheel system to make 6 spokes, that would be considered obvious. Someone skilled in the art would consider doing experimentation or adding another element. The other thing interesting about patents is that there can be a patent for an object. Say there's a patent, a design patent on this hair clip made in South Africa, and if someone were to come by and scale this up or make it smaller, the patent on this product would still hold. So people ask me that, can I make if somebody makes it bigger or smaller, can I still sue them for infringement with my patent? And the answer is yes. So that's, people will ask you, can you adjust things a little bit? And with a design patent, we have the ordinary observer test, meaning if one looks at it, this product and a knockoff, if they see a substantial similarity, you're going to get to sue them for patent infringement. And that's another thing that as a non-patent attorney you can do in federal court. And there's a lot of great patent litigators who are not registered patent attorneys, and they have very, very good careers doing that. The other issue or test for obviousness is, would one find the proportions of the materials or measurements by regular experimentation? So if you have a composition of some salt, some sugar, some water, some caramel, maybe you have Coca-Cola or Pepsi there, and if you were to change those proportions to have a different flavor or something, the patent office would say, well, that's within normal experimentation, and we're not going to issue a patent for that. So in the slide here, we show somebody mixing some chemicals, and then we show somebody measuring things, trying to find different lengths of an element. Okay. The other thing that comes up quite often is people say, well, gee, I have hair clips or some item. What if I make them out of aluminum? What if I make this out of bamboo?